Imagine you are buying an apartment in Berlin. Not just any apartment, but your own. A real one, with a notary, a mortgage, a purchase tax, and the feeling that you have finally entered the upper caste of German society. People who pay for their apartment not to a landlord, but to a bank. And then you get the keys and think, great, in a couple of months I'll move in myself. If you recognize yourself in this, I have two pieces of news for you. The good news, the apartment is indeed yours. The bad news, that doesn't mean anything yet. Because today we will talk about the German legal miracle called Eigenbedarf, personal need, and about why there can sometimes be a distance of 10 years between the phrases, "this is my apartment," and "I can live in it." Yes, you heard that right, 10 years. Therefore, be sure to watch the video until the end. The most important nuance that most owners learn only after purchasing an apartment is that they will not be able to evict the tenant for a very long time. Like the video, subscribe to the channel, and share your experience in the comments. Are you an owner? A tenant? Have you received Eigenbedarf? Have you gone to court? The more real stories there are under this video, the more useful it will be for other people. So, what is Eigenbedarf? It is personal need. To put it simply, the state tells the owner, yes, the apartment is yours, but if someone is already living there, you must first explain why you need it. And not just need it, very much need it. According to the law, the owner can terminate the lease if the apartment is required for themselves or close relatives. For example, children, parents, spouse, grandchildren, brothers and sisters. So if your daughter has enrolled in a university in Berlin and needs housing, that could be a legitimate Eigenbedarf. If after the divorce you have nowhere to live, that too. If elderly parents need to move closer to you, that's quite possible. But if the reason sounds like this, I just wanted to have a free apartment, no. If the reason sounds like this, I want to sell it for a higher price, also no. If the reason sounds like this, the tenant has become annoying, especially no. German courts do not like fictitious personal needs. In fact, they dislike it so much that if the owner evicts the tenant and it later turns out that the story about a daughter, son, grandmother, or personal residence was a fairy tale, the consequences can be very costly. Eviction of the tenant, broker fees, increased rent at the new place, court costs, all of this can turn into a real bill for the owner. But now the most interesting part begins, because even a genuine personal need does not yet mean victory. Let's imagine that you really want to live in the apartment yourself. It would seem that the matter is resolved. But here, German law poses the following question. When exactly did the tenant move in there? It is here that many owners nervously start opening Google for the first time, because there is the concept of Umwandlung, transformation. This is when a house previously belonged to one owner, and then it was divided into separate apartments and entered into the system, one apartment after another, in the land register as separate units of residential property. That is, previously there was one apartment building in the land register, and now there are many separate apartments recorded, and the house is no longer registered. And here arises the question of the century. Did the tenant live in the apartment before this division or after? If after, the situation is relatively simple. The usual rules of personal need apply. But if the tenant lived there before the division of the house into separate apartments, everything becomes much more interesting. So much more interesting that in Berlin, an owner may find themselves owning an apartment they cannot move into for 10 years. Yes, exactly 10 years. This is called the Sperrfrist, blocking period, a protective period for tenants. The legislator's logic is simple, so that no one can buy a house, divide it into apartments, and evict people en masse. Therefore, if the tenant lived there before the division of the house, and the apartment was then sold for the first time as a separate property, a 10-year eviction ban for personal needs usually applies in Berlin. I'll repeat once more, not 3 months, not 6 months, not 9 months, 10 years, and only after the end of these 10 years does the usual procedure begin. And now another unpleasant news for property owners. After the end of the blocking period, the tenant is still not obliged to move out tomorrow, because there are standard notice periods. If a person has lived in the apartment for up to 5 years, 3 months. More than 5 years, 6 months. More than 8 years, 9 months. So it is quite realistic that the owner waits 10 years and then another 9 months. But even that is not the end of the story, because there is a Härtefall, a hard case, a special life situation of the tenant. For example, he is 85 years old. He has lived in the apartment for 30 years. He has a serious illness, disability, dementia, serious mental illness. In such cases, the court may say, yes, the Eigenbedarf is real, but the consequences for the tenant are too severe. And then the tenant remains, sometimes for years, sometimes for a very long time. The courts pay particular attention to cases in Berlin. There, situations regularly arise where the owner genuinely needs the apartment, but the interests of the tenant prevail. Moreover, age alone is no longer an absolute protection. The courts say 80 years is not an argument, shows specific circumstances. Therefore, it is not the one who is older who wins, the one with better evidence wins. And now the main conclusion. Can a tenant be evicted for Eigenbedarf in Germany? Yes, but it is far from being as simple as many apartment buyers think. First, it is necessary to prove genuine personal needs. Then check for any blocking period. Then properly issue the Kündigung, termination. Then make sure that neither you nor the tenant has another suitable apartment in reserve. After that, undergo a check for a severe case. Only then does a real opportunity to win the case arise. Therefore, the most important question when buying an apartment with a tenant is not how many square meters, and not even how much is the rent. The most important question is, when exactly did this tenant move in? Because the answer to this question sometimes determines the difference between moving in 9 months and waiting for more than 10 years.